Introducing the new Pepsi Stuff Catalog. Now, the more Pepsi you drink, the more great stuff you're going to get.
Sure beats the bus.
Is that? I'm sorry. I must be reading that incorrectly. Only 7 million Pepsi points for an entire Harrier fighting jet? If you do the math, about 10 cents per Pepsi point times 7 million Pepsi points, that's only $700,000 for an aircraft valued at $23 million. Well, that's what a man named Mr. John Leonard thought when he saw this commercial.
I did the quick math. I go, 7 million, 10 cents a piece, $700,000.
As a young business student, Leonard jumped at the opportunity. At first, he simply planned to buy a monstrous amount of Pepsi products, just as this promotion had intended. Instead, he found a loophole in the fine print that allowed him to substitute each Pepsi point with just 10 cents, so long as at least 15 legitimate Pepsi points were submitted in parallel. With the help of his friend, Todd Hoffman, along with 4 other small investors, Leonard wrote a check for $700,000, $8.50. Pepsi reps laughed, believing the check to be a joke, and refused the acceptance of the offer. After Leonard responded candidly, PepsiCo offered a $1 million settlement. Leonard, he refused. Leonard v. PepsiCo was the most notable contract law case to come out of the late 90s. It's the quintessential ruling for learning about contract offers and acceptance. More specifically, this case relates to the requirement of objective intent to be bound. Did this advertisement constitute a legally binding offer that a reasonable person would interpret as serious? Well, according to the court, the callow youth featured in the commercial is a highly improbable pilot. One who could barely be trusted with the keys to his parents' car, much less the prize aircraft of the United States Marine Corps. No school would provide landing space for a student fighter jet, or condone the disruption the jet's use would cause. And thus, by virtue of the court, it was decided that no reasonable person could interpret the Harrier jet promotion as legitimate. In the end, the Southern District of New York judge, Kimba Wood, ruled in favor of the defendant. Though, admittedly, this ruling has been questioned, even up to today. One user on Reddit provided a personal anecdote about their experience with the promotion. Me and all my friends made our parents buy Pepsi only from then on out, so we could try to save up for the Harrier. Every kid I knew thought the ad was real and wanted a jet. Pepsi preyed on children and sold a lot of sugar water because of it. As put by another Reddit user, the ad was targeted to kids, and it worked. The judge bailed Pepsi out. The U.S. legal system protects the wealthy and corporations. Regardless of public opinion, the case has managed to set a precedent that all similar subsequent marketing promotions have had to follow. Though PepsiCo won, this case serves as a warning for offers through advertisement. But why does this type of litigation matter for accountants? Well, what if Pepsi had lost? The damages could have been enormous, especially considering the value of a military aircraft. Even though this lawsuit sounds ridiculous, it still generates litigation exposure, legal costs, and reputational risk, all of which matter greatly within accounting. Legal liabilities must be accrued. Litigation risks need to be disclosed in financial statements, and possible losses need to be estimated. Although Pepsi ultimately won this case, litigation demonstrates how marketing decisions can create massive accounting consequences involving contingent liabilities, audit risks, disclosure obligations, and much, much more.